In. Okay. So as I was saying, the title is has to do with presentation has to do with new rules of employers for foreign nationals. And let's go to the first slide. So firstly, we'll talk about the new I-9 form. This came out sort of recently, back in July of 2017. And one thing I would caution employers about in regards to this form is always keep up to date with the edition dates of forms. I don't know what's been going on recently with USCIS, but it seems like they come out with new editions of forms almost every couple of months. And as you can see on the slide there, and if you go to the website to download the form, using an out-of-date edition can cause problems for you, can result in civil fines, penalties, debarments, and other sorts of civil and court actions, which will, of course, you would want to avoid at all costs. Everything else remains the same in regards to the form itself, the retention policies, and a little background on the form is that the use of this form and actually the whole employment verification and sanctions regime came into place with the 1986 Immigration Reform and Control Act. So believe it or not, prior to 1986, it was not a separate federal penalty. There was no separate federal statute which made it illegal to employ unauthorized aliens in the United States. I'll have a slide later on that so we can talk a little more about that, but it's just an interesting point that this whole regime of requiring employers to verify, potential employees' citizenship or lawful status in the United States is relatively new within, the last 30 years or so. Okay, so as many of you probably know, what you have to do when you are vetting a potential employee in regards to employment authorization is there are certain documents that you have to inspect from them. And basically what you're trying to do here is to prove both identity and eligibility to work lawfully in the United States. There are three types of documents. There's List A, List B, and List C documents, and those are included in the instructions to the I-9 form. So, for example, the List A documents, those prove both of the requirements. Those prove identity, because it has a picture of the person, and it proves authorization to accept employment, either as for someone who is going to be a citizen with a passport, or someone who is a lawful permanent resident, or as they're known colloquially as a green card holder. That, again, will prove both identity and eligibility to receive employment authorization, or to receive employment. So the List B documents, those will just prove identity because those have photographs on them. That just proves that this person is who they say they are. It doesn't prove eligibility to receive, to accept employment. So, like, for example, you'll see, obviously, a Connecticut driver's license, that just proves that you're a resident of Connecticut and that you are allowed to drive, that the state has given you permission to operate a motor vehicle in the state. And some states will, for example, have programs that give driver's licenses to unauthorized, to undocumented immigrants. Connecticut is one of them, so that's something to keep in mind. California is another one, I believe Washington. There are several states. Most do not give driver's licenses to undocumented people, but some do. And for List C, that's List C documents, that proves work authorization, because obviously, so for example, if you have an unrestricted Social Security card, and what that means, unrestricted, it just is a normal Social Security card. Because some of the Social Security cards that the Social Security Administration will give out to immigrants, either lawful or unlawful, it can happen. will say, this Social Security card is only valid with DHS authorization. So an unrestricted Social Security card or, a birth certificate proves that you're allowed to work in the United States, but doesn't prove your identity because there's no photograph on any of these types of identity documents. So that's why you can have a List B and a List C document together can prove eligibility to accept employment, or a List A, just a List A, because that proves both of the requirements. Okay, so back in January of 2017, some new rules came out. They're Department of Homeland Security regulations, and they're pretty technical, and a lot of them really don't affect the day-to-day of employers' operations. So the next couple of slides, I'm just going to talk about some of the most important ones. Most of the changes, these came out were promulgated during the Obama administration, still right on the cusp of the new administration. So most of them were designed to make the process more lenient and to kind of streamline it and kind of eliminate some of the ambiguities that are present in the law due to the immigration laws being so complicated and some of them even contradicting each other. Okay, so the first change that could affect employers day to day has to do with holders of employment authorization documents, or EADs for short. These are probably more common than a lot of people think. If you read the immigration laws and regulations, there are dozens and dozens of categories for individuals to accept and receive employment authorization documents, even when you're not technically here legally, or whether you're here in some sort of status that's authorized by the Attorney General, but not a lawful status. There's so many different categories. For example, even sometimes people who have been ordered removed, but for whatever reason their removal order hasn't obviously been fulfilled yet, they can even apply for a work permit in some instances. So you shouldn't. That's just a point of view to consider when you're potentially vetting applicants, and just to know there are so many different types of categories for employment authorization. And another thing to consider with the EAD holders, and this can also come into consideration for some non-immigrants, employment-based non-immigrants like H-1Bs, L-1, E-2, things like that, is the I-9, the re-verification process. Because as you can maybe see on the slide there, so the EAD has a set expiration date. It's valid from one day and then it expires. They're usually valid for 1 year at a time. Some EADs are valid for 2 or 3 years at a time, depending on the category that the EAD is based upon. But just something to consider would be the re-verification process, which is Section 3 of the I-9 form. So employers have to take it upon themselves to make sure that you're cognizant of when someone's employment authorization would expire, and you would have to use that Section 3 of the I-9 to re-verify it and to make sure that they're still allowed to accept employment. Okay. The next one, the next major change that was made has to do with grace periods for certain employment-based non-immigrants. These kind of just clarified grace periods for these employment-based non-immigrants, and basically gives them a little more leniency in regards to when their statuses expire, because like EAD holders, employment-based non-immigrants have a set start date and a set expiration date for their employment. Usually, it depends on the category, but for example, H-1Bs are given out in three-year increments. E-2s are usually 2 years. E-3s are 2 years. L-1s are usually 3 years at a time. So these rules for the grace periods basically kind of codified and made sure that everyone is on the same page in regards to when, if your status has a set expiration date, whether or not, how much time you have to leave the United States or to make plans to potentially change to a different non-immigrant status. And these grace periods are helpful, and when sometimes, if for example you have an employment-based non-immigrant whose status is set to expire October 1st, but for whatever reason, their employment terminates either voluntarily or involuntarily, say in March of that year. That gives them a little time. It would give them, they would fall into the second bullet point up there, so they would have 60 days past the date of their employment termination to basically try to find a new job, new sponsor, make arrangements to depart the United States, or maybe change to a different non-immigrant status, or whatever they need to do to make sure that they're not going to end up overstaying their time here. Okay, the next change, again, kind of codified a rule that was really already in place, but this kind of makes it clear and also added a couple of non-immigrant categories to which it applies. This rule basically says that, so for example, if you have an H-1B employee whose status is going to expire October 1st, but you want to file an extension for them, this rule just codifies the fact that as long as that extension application is filed and properly received by USCIS, and properly received includes having all the proper forms and having all the filing fees paid, as long as that is properly received by USCIS, either on October 1st or up to 6 months prior to that, then that employee will automatically be given 240-day extension of their employment authorization, just with the receipt notice, which USCIS will send to you. And also, it's good to know in practice that even if the extension is pending past 240 days, as long as it's through no fault of the alien or the employer, then USCIS will allow them to keep working past those 240 days. And what they'll do is when they send the approval notice, they'll just backdate it. So any time past the 240 days will be retroactively, and that alien will retroactively be in employment authorized status. Okay. And the next big change that came with these regulations this was actually promulgated after the regulations, this came out, the Trump administration were the ones who spearheaded this. This is a new policy of interviewing employment-based immigrants when they go in for their green cards. Previously, these employment-based immigrants, the interview requirement was almost always waived. So typically, for family-based immigrants, people who are coming here based on marriage to a U.S. citizen or a familial relationship to a citizen or a green card holder, a lot of times USCIS would want to call in both the citizen or green card holder and the alien to make sure that the relationship was legitimate, especially in marriage-based cases, because of the amount of marriage fraud that the government was seeing. But then prior to these new rules, if you were getting your green card based on employment, the government didn't really bother interviewing you. The attestations on the forms that were signed by the alien and the employer were good enough in the mind of USCIS to basically verify the information in all of the forms. But now the government is taking the position that those attestations are not enough, and they want to interview employment-based immigrants who are going to be getting their green card based on having a sponsor, an employer sponsor. And as you can see, the purpose, according to the government, of these interviews is to discover new information that may be relevant to the adjudication process. So again, they basically want to hear it directly from the alien themselves in the form of an interview as to how how they came about to get their position. They also want to verify things that like the wage, specifically the wage, because as a lot of you probably know, one of the requirements for sponsoring a lot of these aliens in a lot of the employment-based non-immigrant and immigrant categories is that you have to pay them a certain wage. It's known as the prevailing wage, and it's dependent on the job category and the geographic location of the employment. So that's definitely one thing they want to make sure that is happening, is that the alien is being paid at least or above the prevailing wage based on their job category and their geographic location, which, interestingly enough, will bring me to the next slide, which is, like I alluded to earlier, I was going to talk a little bit, just to give a little context and to make this maybe a little more interesting, to talk about the history of the employer-based sanctions regime and the Immigration and Nationality Act. So, yeah, like I was saying previously, prior to 1986, which was the year that IRCA, the Immigration Reform Control Act, was passed, it was not federally prohibited to employ an undocumented immigrant in the United States. It's not to say that people who were working illegally didn't get caught up and deported, because that certainly did happen, but they weren't deported because they were working illegally. They were deported because they were present unlawfully, or they had committed some other violation of the Immigration and Nationality Act. Even prior to 1986, some states took it upon themselves to make it unlawful to employ undocumented people, but there were only a handful of cases where any sort of fine or sanction or enforcement was taken against an employer who did so. And this is kind of interesting because at the time, people who traditionally, or at least who in today's political sphere would probably be very much opposed to strict enforcement of employer sanctions and things like that, actually supported the law. So, for example, big labor groups, the AFL-CIO, even some other groups like the NAACP were in favor of passing this IRCA, and specifically the employer sanctions part of it, because they saw it as a way to protect American labor. And you can see why labor groups would have supported that. I guess there may be some things have changed politically over the past 30 years to kind of put them on the opposite side of that, but that's neither here nor there. And it was controversial because it's sort of, in a way, the law forcefully deputizes employers and kind of makes them agents of the federal government and puts them basically on the front line of enforcing immigration law. So that was seen as controversial back in the day, back in the 1980s when this bill was being formulated. But it's been the law of the land for more than 30 years now, and it's most likely not going to be changed, at least be changed to favor, to be changed in a more lenient fashion, at least not in the next couple of years or so. You never know what could happen with what would happen with the government or administration or political changes, but just something that I thought was interesting and is relevant. Obviously, it kind of gives you the history of where these employer sanctions regime come from. Okay, so yeah, I guess continuing with enforcement. So over the past 5 years, ICE is Immigration and Customs Enforcement. They're part of the Department of Homeland Security. They're tasked with internal immigration enforcement, while some of you, I'm sure, have heard of, the Border Patrol, which is tasked with, or the U.S. Border Patrol, or Customs and Border Protection, which are tasked with immigration enforcement at the border or at the edges of the border and at ports of entry, points of entry, airports, stuff like that. So ICE, as an agency of the Department of Homeland Security, conducts internal enforcement, and they have audited 10,000 employers and imposed more than $100 million in sanctions over the past 5 years. So that goes back, obviously, to before the current administration. So it's not like there wasn't any enforcement prior to 2017 or anything like that. But now with the new administration, they do plan to ramp up employer-based enforcement actions. And specifically, the director, I believe he's still the acting director of ICE. His name is Thomas Homan. He has stated publicly that ICE plans to conduct 4 to 5 more times the worksite raids in 2018 than they did in 2017. And there's a slide later about this. I think he might have said that specifically in reference to some actions that California had taken. Again, interesting dichotomy, the way it works between state and federal law in regards to immigration. So an example of this enforcement action would have been the raids on 7-Eleven, which took place earlier this year. It was tons of, it was many different stores all over. And again, the reason that these worksite enforcement actions take place is because in the minds of some people, jobs and employment is the main attraction to people immigrating illegally to the United States. So that they're of the opinion that if you cut off the jobs, then you'll cut off the illegal immigration. So that's why you could see would be the reason that this administration would really put a focus on worksite enforcement. And as the last bullet point there, it talks about certain industries are more prone to enforcement than others. Construction and the restaurant industry are two that come to mind right away. So that's why it's really important when you're dealing with contractors and subcontractors to make sure that the responsibility is properly delegated to the party who should be responsible for verifying someone's work authorization. Okay, so continuing with that, one of the primary ways that ICE enforces the law internally in the United States is with the I-9 audit and administrative fine procedure. So basically, they could serve you with something called a notice of inspection, and then you'll have a very short amount of time to basically get your documents in order, because the notice of inspection basically says we want to inspect your I-9s and make sure that you've been keeping records properly. It's an audit. That's what it is. They want to make sure that you're keeping records properly, that you've taken the proper, you've done everything properly in keeping records and inspecting employees' documents. Make sure they showed you the right sort of documents, and also, they want to make sure that you're not discriminating against anyone based on nationality. And obviously, we would recommend, or I think anyone would recommend, the best insulation against this sort of sort of audit is to do your own audit, before the ICE is the one auditing you. Because if you audit yourself and you find you made some mistakes, no one's going to, ICE isn't going to know about it necessarily. But if they're the ones doing the auditing, then that's when fines and administrative and possibly criminal actions could come into place. Okay, and this is kind of just basically, again, emphasizing what I was saying earlier. A lot of the new enforcement regime is coming from the new administration, and some of the presidential executive orders that were issued earlier, either earlier this year or last year. And another interesting way that the government is kind of doing backdoor immigration enforcement is through tougher adjudications of the employment-based non-immigrant and immigrant petitions. So, for example, last year we saw a significant increase in the amount of and just in the amount of requests for evidence that the USCIS sent out for H-1B cases. And basically what that means is that USCIS was trying to make it as hard as possible to hire a foreign national using the H-1B program. And that, again, could be pressure from outside groups and even the media. There have been a lot of potentially not so flattering media reports about the H-1B visas. People say that they are used to undercut American wages. And I guess USCIS, under the new regime, heard those arguments because that's exactly what the requests that they sent out were about. They were saying, look, we don't think you're paying this guy enough based on the job duties that he's going to perform. Or they'd hit you from the other way, and say these job duties are too complex, and so basically that's just kind of a backdoor way that the government is also ramping up enforcement without doing raids or audits. Okay, and this slide, the biggest point to take from this slide has to do with the last bullet point there, with you cannot knowingly employ an unauthorized alien. So the key word being knowingly. The legal standard is that you have to make a reasonable attempt to verify someone's documents. If someone hands you a $10,000 forgery and it looks just as good as a regular green card or a passport, it's not your responsibility to hold it under some ultraviolet light or something like that to make sure it's real. It has to appear reasonably, it reasonably has to appear to be genuine based on an inspection of the document. So that's the standards, and the government can be fairly forgiving in that regard. They just want to make sure that you're not knowingly employing people that have no legal authority to be here. Okay, and this is just a little breakdown of, you see the visual there of how an audit or an inspection would work. They'll give you the notice of inspection. They'll give you a set amount of time before they come back and say, we're going to inspect the forms. And then, a myriad amount of things could go right or wrong here. They could say, we, based on, our review of the documents, these look suspect to us, or there's some discrepancies. Or they could say, all right, this all looks good, and we're going to leave you alone now. But that isn't always the case. It could be technical or substantive violations that could result in more warnings or more notice of fines, and then potentially, if you get down to the bottom there, you could end up either having to settle with the government for violating the law, or you could go to a hearing before this OCAHO, which is Office of the Chief Administrative Hearing Officer. It's an administrative law court. It's not like a federal. It's not like a federal district court, but the penalties that they can impose are very real. So I guess it doesn't have to be a federal court with an appointed judge. So let's go on here. So this slide is just about a few of the common I-9 errors that are seen. It can be difficult to strike a balance between ensuring between complying with the law and hiring only people who are allowed to work lawfully in the United States, and discrimination laws, because you can't discriminate against a potential employee based on nationality, whether their nationality be American or some other nationality. And you cannot require them to overprove their eligibility documents. So, for example, if someone gives you a work permit that's valid and you've inspected it and it looks facially valid to you, you can't also ask them to give you a List B or a List C document on the I-9 form. That's just the rules. You can't have them overprove their eligibility. And yeah, you got to be careful, because it can get pretty precarious with the government stepping in and accusing you of discriminating. Either They can accuse you of discriminating against Americans. You say, we don't think you're going to hire Americans for whichever reason, or they can accuse you of discriminating against foreign nationals and say, you're not hiring foreign nationals for whatever reason. So it's a very fine line to walk, and it can get quite difficult. Okay. Next slide, E-Verify. E-Verify isn't new, but I thought it would be good to talk about because it's very realistic that it could become mandatory in the not-so-distant future. So basically what E-Verify is, it's a program with the government where it's not mandatory now, but like I said, it could become mandatory in the future, and I'm sure that certain people in the current administration do want to tack this on to any potential immigration bill that they would submit to Congress. And it basically is a program whereby you work with the federal government to verify someone's employment eligibility in the United States. The government agencies will use the data that you submit to them to match it against their own record books. And the end goal is to figure out whether this person is allowed to accept employment in the United States. It can be very useful because it sort of takes some of the responsibility off of employers, in as much as they're not so much the frontline deputies anymore that maybe IRCA had envisioned of them. But also can be burdensome because, as I'm sure you know, federal government records are not always accurate. So sometimes you can get the false positive where you get a hit and they'll come back and say, you know, we don't think this person is allowed to accept employment. And then that just creates extra work. You have to go back to the employee and say, we got a result from E-Verify that says you might not be eligible to accept employment, and then they have to produce more documents. So it can be useful or it can be a burden, depending on the situation, I guess, like most things. Okay. So this slide is about just a little bit about the employer's responsibilities to the Department of Homeland Security in regards to notifying them of changes either in their own corporate or company structure or in the employment of their foreign nationals. So it's definitely a good idea to keep a separate roster or a separate spreadsheet or some sort of record of the foreign nationals who are working for your company and when they might require an extension or when their employment authorization might expire, and that's useful for this purpose and for the I-9 re-verification purpose, which I had touched upon earlier. And also, it's good to keep a record of any changes to their employment, because sometimes something simple like a promotion or a salary change could require filing like an amendment to USCIS, basically saying, you know, this person is still employed with us, but we made changes to their employment. He was promoted, or he works in a different job now. He works at a different wage now. He works in a different location now. All those sorts of things are going to be relevant to whether this person is going to remain authorized to accept lawful employment, and it's the employer's responsibility and burden to keep USCIS up to date with any of those changes. So this is just a little slide, what I was talking about earlier with the state versus the federal government in regards to who sets immigration law. So the Constitution clearly says the federal government sets immigration law. Some states, I guess the Supreme Court has given states a little bit of wiggle room to legislate in the realm of immigration, but that has created lots of problems, lots of lawsuits. The Attorney General is suing the state of California right now because of this dispute. And that's because California just passed a law that puts employers in a very difficult position. Basically, it says that employers cannot cooperate with enforcement actions without a subpoena. compelling them to do so. And ICE just doesn't operate that way. They don't get subpoenas to do their worksite enforcement. They just have administrative warrants and administrative actions. So it can create friction, and it's something to watch and something to take into consideration. Keep an eye on local laws and see what they're doing in the realm of immigration and employment. Okay, so then the last slides here are just kind of touching upon what an employer or an employee would do if you were served with or if ICE came to your establishment and started asking questions or anything like that. So ICE is a law enforcement agency. They just enforce immigration laws. They have, just like other law enforcement agencies, they have to obtain a judicial warrant. That's a warrant signed by a judge in order, or affirmative consent from an employer before searching or seizing private property. ICE usually just uses administrative warrants because it's much easier for them. They don't have to go to a judge, and I mean these are acceptable. They're just not judicial warrants. Just like anyone else, if you run a business that is open to the public, ICE officers can go in and examine public spaces, but they're not, obviously they wouldn't be allowed in a private area of an employer or of a business without that first getting that judicial warrant. And if an officer comes in and starts asking you questions, looking around, make sure to ask to see their warrant, just like if they were to come to your home, or police officers were to do that, and search your home, you'd want to see a copy of the warrant, and you have a right to do so. Okay, so for employees on site, the Constitution mostly does apply to people here, even in undocumented status. Again, ICE must have a valid search warrant or consent to enter private areas. And the last thing that you want employees to do is kind of scatter or run or not remain calm if ICE shows up, because then the situation could escalate quickly and get out of control. So there's no reason to run or anything like that. Just employees should remain calm and try to cooperate to the best of their ability. With that being said, though, they do have the right to remain silent. You don't have to answer questions about anything, and especially the employees don't have to answer questions that would give ICE the inclination to think that they're a foreign national or that they're not authorized to accept employment. You're not required to show identity documents, especially ones that would demonstrate foreign origin, such as a foreign passport or some sort of other foreign identification card. So again, the undocumented employees would have rights, just like anyone else, to remain silent and to potentially see or speak with a lawyer. And you do not obviously want to be showing any sort of false documents to any sort of ICE agents, because that could constitute fraud, and especially if this person is trying to take steps to legalize their status here in the United States. Showing a false document to a federal immigration officer is an automatic bar to admissibility, and that would certainly complicate things and could result in having to obtain a waiver, and it's not good. So the moral of the story is, cooperate with ICE. You don't have to treat them as enemies or the bad guys, but you also don't have to basically help them to do their jobs. So with that, I think that's the last slide. We have come to the end of our program. I hope that you found the information helpful. And you can let me know if there are questions, and I will take those. And we'll just give it a minute to let any questions filter in, or if anyone, yeah, questions, we'll take those. Okay. So yeah, I guess we have come to the end of our program. Again, all of today's participants will be receiving an email with the PowerPoint slides, a link to the webinar, and an attendance certificate. Be on the lookout for those items. If you have any additional questions, please feel free to reach out to me or to Jackie Rowe. Thank you very much, and we hope you found the presentation helpful.